So greetings, everybody. It's really a great pleasure to introduce this panel, given what's going on every day. I haven't checked over the last hour if I'm missing some breaking news, but my name's Gregory Schaefer. I am Chancellor's Professor at the University of California, Irvine, and I've been working on trade ever since I started my career, and that was back in the late 1990s. And I guarantee you that they never placed a trade panel in a big room like this before at ASIL. And so clearly something has changed. Maybe is it the end of trade in terms of a multilateral system of rules and dispute settlement? Well, here to discuss some of the issues, I have very distinguished panelists. So I'm going to start with my right is Irving Williamson, who's a commissioner at the International Trade Commission. I first spoke with Irving years ago when I worked on my first book called Public-Private Partnerships in WTO Litigation, trying to address what was the interaction between the private sector and private companies and lawyers and the US government, and how Section 301 was actually used in practice. And so Irving both has the background of having worked in the USTR on Section 301 cases and how it was used strategically, as well as now being at the International Trade Commission, making decisions on cases such as with respect to safeguards on solar panels, washing machines, and so forth. And he's been working over 50 years. I should also say, Irving, for a while before his USIDC appointment, he is for 7 years president of Williamson International Trade Strategies, Inc. And so he's also worked with the private sector and with respect to trade and development issues, in particular with respect to Africa. So that'll be great to get that perspective as well. Next, I have Beth Baltzan. Beth also has worked in the General Counsel's office at USTR, so she has litigated issues at the international level on behalf of the United States on many of the types of import relief matters which we now see before us. And she has been also a consultant for the Center for American Progress. She also worked in the House of Representatives. She knows the politics of these issues as well as the legal issues. She worked in as trade counsel to the U.S. House of Representatives, the Ways and Means Committee, as a Democratic staffer. And she has also given some thought, and she also has blogs. You can check her blogs with respect to how to think about something that's actually very important to me, how to rethink about trade agreements from a progressive perspective with respect to issues of inequality and social inclusion, which I think give rise to many of the challenges that we see today. Next, we have Timothy Brightbill. Tim is a partner at Wiley Rein with lots of experience on international trade litigation. And in particular, he's worked on anti-dumping, countervailing duty, and safeguard proceedings on behalf of clients. And he's also an adjunct professor at Georgetown University Law Center just down the road. And Tim is a representative for the petitioner in the solar panels case on safeguards. So he can give us an up-to-date understanding with respect to the legal issues and we're at the stage of the proceedings. And then finally, we have Jeannie Davidson. Jeannie's been working for a long time on trade issues. She also, at one point earlier in her career, worked for USTR. But for the longest period of time, she's been in the U.S. Department of Justice. And Jeannie's actually defending the administration with respect to its 232 findings before U.S. courts, which are now being challenged, and its safeguards finding on solar panels and so forth. So we're really fortunate in this area, which is incredibly technocratic and incredibly detailed, but also raises huge public policy issues to have people who can give us the update on where things now lie and how the processes work from within government, but also from a broader perspective. I've asked everybody, I guess a couple of things. One, of course, we have someone who works with clients, and clients also being the U.S. government. And so we're subject, as all ASIL panels, to Robert's rules, where people will be speaking under an individual capacity. But the idea is to have a forthright as of a discussion as possible, and one which is analytic, which really doesn't just defend a particular client's perspectives, but to lay out the issues and the arguments on both sides. And so that's what we're going to do to you. I see that we have lots of people with lots of experience in the audience too, so we're going to try to reserve some time for questions, so please have your questions prepared. I've organized this really in terms of more of a question and answer in three parts. One, just to look at what's happening in terms of U.S. domestic trade law and the different proceedings. We'll spend some time on that. Then we'll talk about some of the international trade issues at the World Trade Organization and what the implications are. And finally, we'll wrap up by asking the big questions. How did we get here? And how do we get out of here? And so with that, we're going to start just by talking about domestic law practice. And before we move to the special actions of 232 and 301, let's talk a little bit about what's happening in anti-dumping investigations, countervailing duty investigations. Do we see, in terms of practice, do we see anything, is there something new? Is it ongoing? I mean, in some ways, it seems like the traditional economist's argument is that when the economy's not going very well, you see more anti-dumping investigations, and when the economy's going well, you see a decline in them. Do we see an intensification of anti-dumping? Do we see sort of a large number of petitions? Do we see, in terms of target countries, obviously China's been covered, do we see other countries now being targeted that weren't being targeted before, and so forth? So what's the same, what's new?
Okay, I guess the first point is the number of anti-dumping countervailing duty petitions that are being filed has gone up, and we're now at the record level. We haven't been this high since the early 2000s, and see no sign that the increase in filings is going to slow down. And I think one thing I could say is that being more and more a diverse set of products and a diverse set of countries. I remember when I first came to the convention in 2007, it seemed like every case involved China. And now we're seeing a lot of cases that don't involve China. Sometimes it's products that originally there was a case filed against China, and now it's that the imports are gone to someplace else. But in terms of the volume of caseload, of the number of cases, it's steadily going up.
Okay.
I'll just, well, first of all, thank you for inviting me to be on this distinguished panel. I've had the pleasure of working with all of these panelists for many decades, so we all know each other pretty well, and I'm depending on them to speak where Irv and I cannot speak. But I would just mention three new developments from my experience. One is a renewed use of self-initiation at the Department of Commerce. So there have been several self-initiated investigations this year that hadn't been done since, I think, 1995. A second development is a much greater willingness on the part of the Department of Commerce to look at fraud and to apply adverse sort of inferences or adverse information available when it finds fraud. Historically, the Department of Commerce in unfair trade practices believed that it was not an investigatory agency and was not trained or equipped to investigate fraud, and so it tended to take representations at face value, or if the representations were outweighed by other evidence, just treat this as an evidentiary issue. But it now has gone further and actually found that when particular companies have committed fraud, and that has been determined and has taken adverse steps against them. So that's a warning for any of you out there who are representing parties before the Department of Commerce. And the third development that I've noticed is sort of a new definition of domestic industry. I mean, back in the day when I first started, the domestic industry meant American-owned producers, and over time, many of those American-owned producers were acquired by foreign owners, and there was sort of a question of, what are these like hybrid companies? Are they really American companies, or are they foreign companies? And that had an impact in trade cases because foreign-owned businesses in the U.S. often would not support unfair trade practice investigations. Today, it seems to me that domestic industry means you have a plant in the U.S. that employs people in the U.S. And you see, for example, many of Tim's clients who are domestic companies are foreign-owned, in fact. And Bloomberg reported that at the signing ceremony for the Section 232 order, that a third of the steel companies who were present in the Oval Office were actually executives of foreign-owned steel companies operating in the United States. So that's a change that I've seen. It didn't occur just this last year. It's been over several decades. But I now think we have a new sort of definition of domestic industry.
Thanks, Greg, and for putting this together and for everyone attending. I got to start with my standard, actually an enhanced lawyer disclaimer. I always say these are my personal views, not those of my clients or my law firm. Some of what you're going to hear today are not even my personal views. There may be the arguments of the administration, which I may agree with on some points, but might not on others. So extra big disclaimer before we start. But that being said, I agree with most of what, with what Commissioner Williamson and with what Jean said. Certainly there are more AD and CBD cases being filed. For us, primarily representing petitioners in domestic industries, we see country hopping. We see global chains of production that didn't exist 10 or 20 years ago. And so if it's easier for a large foreign company to move sources of supply, it means that first, there's more likely to be a need for follow-on cases or broader cases that address a number of countries at once. There's definitely a move from more basic products to more value-added products. So that's China moving up the value chain, which I think we'll talk about, and other countries as well. So not just steel, but steel products, not just wood, but wood products, furniture, hardwood, plywood, all the way through renewable energy, which is a fairly new sector, solar, wind towers, and others. I think Jean's point about self-initiation is a very important one. Commerce, while having limited resources, clearly has an interest in bringing self-initiated cases in the proper circumstances and is very open to working with domestic industries to make that happen. We also see some changes due to changes in the law. The 2015 Enforce and Protect Act that Congress passed has changed commerce's practice in some respects with respect to adverse facts available, as Jean mentioned, also with regard to whether a particular market situation exists in a dumping case that might cause distortion and require commerce to use a different method of calculating a dumping margin or a normal value. So I think those are all things that I see going on, as well as certainly more evasion and circumvention activity, which also is addressed in part by the new law.
Okay. So this is more of an academic speculation, but why do we see these differences? On the one hand, in terms of the diversity of target countries. So I can imagine one, and the quickest answer would be this is just a question of anti-circumvention, that it becomes easier today to move manufacturing bases quickly from one country to another than it was in the past. Do you think, the anti-circumvention rules have been there for a long time. They've been upgraded or updated. But is this part of the global supply chain revolution that it's just companies can shift, they have many different possibilities as sources of supply, and so in a sense they can act much quicker than government, and government's always reacting to what they are doing, and this is, or do you see it as something else in terms of what's going on?
Okay. Actually, I really should defer to Tim on this, but let me also say thank you very much. It's a real pleasure to be here at this ASI event, and also to emphasize that these are my own personal views and not views of the commission or the government. in terms of the answer, I guess all of the above, but maybe Tim may have better ideas with exactly what. But as I say, clearly there have been a series of cases that we've seen where as soon as the orders went on one country, it seems like they started producing the product in another. And it's just that those have stood out. But again, we also have the global supply chains, and there's just a number of other factors and why that's getting coming from more countries.
Yeah.
I guess I would just say two things. First is global supply chain, as we've already talked about. Second is, even though the economy writ large is doing better, clearly U.S. manufacturing is not doing better. Our president made a great point of that on the campaign trail. And so I think even though the economy is strong, there are plenty of domestic industries that have been harmed, and in their view, dumped and subsidized imports are at least a cause of that harm. And so, and imports continue to increase in many of these sectors. So I think it's a combination of those things leading to new cases.
Okay, great. What about use of countervailing duty proceedings? So much of the complaint with respect to China has been that it involves a form of state capitalism, which is simply unfair because they subsidize everything. And be it inputs, be it loans, be it energy, materials, and so forth. Do you see sort of a greater use of countervailing duty proceedings than in the past, or is it still most of the action lie in anti-dumping proceedings?
Actually, yeah. For the commission, it really doesn't matter in terms of our procedure. So I guess it's really Liz or Tim.
Well, for one thing, the countervailing duty law has only been applied to China for, I guess, 10 years. So that's certainly one major change. But I think what we see over and over again is sort of a pattern predominantly by China, but other countries are involved too, and there have been a number of subsidy cases involving India, Korea, Turkey, in particular subsidy programs within those. But we see for China, of course, a 5-year plan targeting particular industries and particular sectors. That leads to subsidies at all levels, national, provincial, local. That leads to overcapacity, and again, it's not just steel, it's solar panels, it's hardwood, plywood, and the list goes on and on. And then that leads to dumping, huge increase in import market share, and harm to the U.S. industry. So that's the pattern that I think has occurred over and over again, and it's one that the Commerce Department and the Commission have seen over and over again as well. So that's what is replicated in these cases that have increased over time.
Okay, great. I remember, well, when one thinks about trade liberalization, it involves state-to-state negotiations, and so it's not private-driven. And this is way back when there used to be debates as to whether or not there should be private enforcement of trade rules. Should they be self-executing in Europe and the United States and so forth, and that went nowhere. But as we know, there is, in terms of protectionism or import relief, it's always been privatized. It's always been driven by private sector petitions and so forth to demand implementations of these at the domestic level. To what extent, how great has been the turn to self-initiated disputes in terms of the historical pattern of the government initiating the import relief investigations on its own? And what are the implications of the government doing it besides leaving this to the private sector to bring the petition and defend the petition?
I guess from the ITC's point of view, and we've made this clear to Commerce, the only concern we have is that we have to determine whether or not a domestic industry is being injured.
Yeah.
And the data and the information that domestic industry provides us is crucial. And when you have when a petition is filed, we only have 45 days to vote on making a preliminary determination. And so if we're concerned about getting the data we need to make that decision fairly, and so whether or not Commerce self-initiates, the domestic industry really has to get in there and provide us the data and the information, and we would expect respondents to get and provide us their views so we can make a sound decision. So that's just our so we can do our job, we need the information, and we need the domestic industry's involvement in the case.
Yes. Does it matter for clients, Tim, if it's self-initiated or when industry gets involved? Yes.
Well, if you're talking about initiation by commerce,
Yes.
there's only one that's happened, so it's probably too early to draw a whole lot of conclusions, but I do think there's a potential benefit for industries that are very diverse, where it can be more difficult to show that the industry has standing to file petitions on its own. So I would think that one potential trend we will see is commerce looking to self-initiate cases where that are broader in scope, or where it might be difficult to ascertain the level of industry support, because that support requirement, standing requirement, is not there in the same way for a self-initiated case as it is for a case filed by an industry or by petitioners. Another related point is that industries that face these issues have two options. They can file a countervailing duty case. They can also try to convince their government to bring a subsidy action at the WTO. We've seen an increase in CBD cases. I'm not so sure that we've seen an increase in subsidy cases at the WTO. And the ones that we have seen have been big, complex cases that maybe haven't resulted in what the companies might have hoped for. So I think that's sort of an interesting thing. And I know we'll talk about WTO quite a bit more as we go.
Okay. Thanks,
Sorry. Just as the lawyer for the Commerce Department in litigation, I would just add that people are usually very enthusiastic about self-initiation because it shows a commitment by at least the Commerce Department to investigate. It's not just reacting in a passive way to a petition that's been filed, but even at the Commerce Department, a self-initiated investigation requires a strong level of involvement by the domestic industry. The Commerce Department can commit the resources, but it doesn't have the industry expertise that the industry itself has, and so people should not expect that just because Commerce has self-initiated a case that Commerce is going to carry the ball all the way down the field all by itself, successfully anyway.
So to turn to we looked at claims about unfair trade. Now just to turn to safeguards. The major safeguard that was implemented with respect to solar panels and washing machines, it's gotten a lot of attention because, at least for green energy advocates, this makes green energy more expensive in the United States as opposed to less expensive. And the safeguard is not based on some unfair practices in other countries in terms of pricing or subsidization, but it's just based on the fact that other countries are producing at a competitive rate, which is causing injury to the U.S. industry. I was wondering if you could say a little bit about the Section 201 case. First of all, just in terms of historical perspective, I believe the last time we used Section 201 was in 2001, so it was at 17 years ago. So it's not very frequently used. It's a signal when we do use it. What's the sense of why there was a turn to use this instrument as opposed to other instruments? Where this is being challenged now, Jeannie's working on this case, and as well as Tim, and so what is the current stage of legal proceedings with respect to the particular challenge of those who are facing the duties on solar panels? And who's participating? Do you see consumer groups or downstream industries and so forth? And just to throw out a lot, in terms of justiciability, what's the record of a 201 determination ever being overturned? I believe there's probably scant hope for the complainants. But if you could give us some background of where we are today and what sort of arguments are being raised and so forth.
Okay, I can try and kick that off. I feel like if I was in court and the judge asked that multi-part question, I'd be furiously scribbling. And again, our firm does represent Solar World Americas, which was one of the two petitioners in the case. So you can feel free to take everything I say with that in mind. But it's true that there had not been a safeguards case prior to these two cases on solar and on washing machines. since 2001, when President Bush initiated the steel safeguards that resulted in 30% safeguard duties put on steel imports in 2002 until those were taken down by the WTO. And it's also true that the WTO has reviewed safeguards determinations very aggressively and has not hesitated to find fault with not only the United States but other countries' use of safeguards. And in particular, there are challenges. For one thing, the causation standard and the injury standard is very high in a safeguards case, and so I think U.S. companies and industries have chosen to file traditional trade cases where they have to show material injury rather than the imports being a substantial cause of serious injury. Also, the WTO and the appellate body read in the requirements of Article 19 back into the safeguards agreement, which means there needs to be a showing that the increased imports were as a result of unforeseen developments, something that many people believe was not intended to be included after the Uruguay round and after the creation of the Safeguards Act. And there were a number of commentators that said that basically that raised the bar completely on these cases. Nonetheless, a number of countries do file safeguard cases. There are 20 or 30 cases filed every year. Some developing countries use them sort of as a substitute for AD and CBD law. It's more difficult to circumvent or evade a safeguards case. You can put them in place for a year or two. And so there are a number of developing countries that sort of fly under the radar with their use of safeguards law. That being said, the solar case, I can just review very briefly. There was a substantial surge in imports from around the world, up to $8 billion worth of solar cells and solar panels that entered the United States in 2016 as compared to $3 billion, already a high number back in 2012. The Commission made a unanimous finding of serious injury and that the surge of imports were a substantial cause of that injury, recommended various remedies to the President, and the President put in place tariffs starting at 30%, which are now in effect, declining over a 4-year period. The President declared 4 years of relief, which is somewhat unusual. Normally, the United States declares relief for 3 years and 1 day for arcane reasons that many of you probably know. There was also 2.5 gigawatts of solar cells were allowed to enter into the United States duty-free. So that first amount is not subject to any tariffs. Most countries, including free trade agreement countries, are subject to the remedy. Canada was not found by the Commission to account for a substantial share of imports or to contribute importantly to the serious injury, but President Trump did include Canada in the relief, as he is able to do under the law. Most developing countries were excluded. There is ongoing litigation right now. Canada in particular filed an appeal and asked for a temporary restraining order and a preliminary injunction, both of which were denied by the Court of International Trade. There's now an appeal to the Federal Circuit that's in the process of being briefed and may be decided shortly. And then there'll be underlying appeals on the merits, of course. And then there are WTO challenges underway as well. Not only China, but several other countries have announced, have requested consultations. And one notable thing, I think, is that countries have announced their willingness or ability to suspend concessions in equal amount. It's a little unclear whether saying they will do this immediately or at the end of a litigation at the WTO. China, in particular, has said that they reserve the right to take retaliation or suspend concessions because the measures were not based on an absolute increase in imports. which I disagree with. In solar, at least, there was clearly an increase in imports from around the world. But so we have ongoing U.S. appeals. We have ongoing WTO appeals that are just beginning. Nonetheless, this was not, this will be my last point now. I could say a lot more, but there's been a lot of characterization in the press that this was a political act, that this was partisan and protectionist. I mean, this was a full investigation. It was compliant with the Safeguards Agreement and with U.S. law, based on a unanimous bipartisan determination by the Commission of serious injury. So I just think that's important to keep in mind as we talk about all of these different types of actions that have been taken in the last year, that this one was based on a year-long investigation, and the tariffs implemented by the president, I'd also say, were less than what the domestic industry asked for, and even such non-Trump supporters as Al Gore said that he understood why the president did what he did, and that he actually chose relief that wasn't as harmful to consumers as he could have done. So that's a lot. I apologize for that long answer, but I'll turn it over to my colleagues.
Tim has thoroughly covered it.
Jeannie, okay.
I won't repeat anything, but I just wanted to clarify that the plaintiffs in the solar panel cases are Canadian producers, but the government of Canada has been granted leave to file an amicus brief. And to answer the question of the government's track record in 201, we have never lost a case so far. It could always happen. I would note that from the Department of Justice's perspective, and I actually have been there since the very end of the Reagan administration, and so I've been involved in a lot of presidential proclamations under various discretionary trade statutes. Our analysis is always the same. Does the court have jurisdiction? Do the plaintiffs have standing? Is this decision justiciable? If it is, what is the standard of review? And it's always a very limited standard of review, but there might be some variation depending on the statute involved or the court involved. So we look at each case sort of the same way. And sometimes when we are litigating a case, it might seem very different during the day when we're working on the case than it is when we get home and watch the television and read about the case that we're handling. But we'll see how this one comes out.
Yeah. Can you say a little bit on what the arguments of those challenging the safeguard measure are?
What the claim is?
Yeah, the claim is.
Well, the claim, actually, I didn't want to get too much into the weeds, but actually the ITC is a named defendant but has moved to dismiss itself from the case because, in fact, the plaintiffs are not alleging any error by the ITC. The plaintiffs in the case like actually what the ITC did, which was to provide 4 slightly different recommendations of a remedy. And while I don't want to characterize their claim, as I understand it, their argument is that because there was not a majority recommendation from the Commission on remedy, the President could not adopt any remedy.
Okay, great.
And there's, I would say, and there's been a number of 201 decisions in the past where the Commission hasn't come up with one remedy. Yeah. Although actually in this case it was 3 because I always paired it with somebody else.
But wasn't there always at least 3 or 4 commissioners who came up with a single?
Well, there are only 4 commissioners. And,
right. Well, there are 2 vacancies, but isn't this the first time that there hasn't been a majority commission proposal for 201?
Actually,
no?
I'm not sure about
No.
that. No, I wouldn't go that far. The other point I would like to make about this is that how thorough this proceeding is. I mean, we had a big hearing on whether or not there was injury, and that was proceeding. Then a month later, we had to make it, once we went affirmative on injury, there was a separate hearing on remedy. These are industries that, in both cases, there had been at least 2 dumping cases before, so the Commission was very familiar with the industry and the issues. So it really was a very, very thorough process. Mm-hmm. And I mean, not an easy process, but it was thorough. And
okay. That's a good setup for turning to Section 232, which is a provision in which there's an investigation of imports which represent a threat to national security. It's a trade, the last time that this was actually used was during the Reagan administration with respect to machine tools, and that was in 1986. So it hasn't been used since the creation of the WTO. And it's arguably the use of this particular provision of existing trade laws has raised, at least among some, concerns about constitutionality, that is the delegation of authority to the president to make a determination of what tariffs will be on national security grounds. And the challenge is it really was a pretext because given not only the tweets of the president, but also just in terms of the policy implications of using this as bargaining leverage to try to get better, to renegotiate certain trade deals with Korea or NAFTA or so forth, that it couldn't really be about national security, as about something else. So, but I thought it'd be nice to maybe talk a little bit about just what's different between a Section 232 investigation, which takes place within the Department of Commerce, compared to a safeguards investigation in terms of procedures, notice and comment. This is, of course, also the finding was all steel, whereas an anti-dumping investigation would be, there's lots of different types of steel products. Some may cause injury, others may not, but this was very broad in scope. So I was wondering if we could you could give a bit of an overview of the difference between a 232 proceeding and what was just described by Commissioner Williamson as a very thorough process of a normal safeguard investigation.
So I can say a few things on that. I mean, obviously, you're right. Section 232 is not a safeguards investigation, and it shouldn't be treated like one. And you know, an analogy to a safeguards case is incorrect. And I think it's interesting now with the talk of retaliation that some of our trading partners are attempting to characterize what the United States did as a safeguard measure, but it's not. It's a national security investigation. It's also, national security is defined very broadly to include things like critical infrastructure. So one of the industries that we represented makes large diameter pipe for pipelines. So if you think about infrastructure, certainly it's not just military. It includes, or arguably does include things like pipeline or electric utility or whatever. And also, by the way, steel and aluminum, both. There were two 232 investigations. The investigation was conducted by Commerce, but by the Bureau of Industry and Security, BIS, which has always done these and is separate from the entity that conducts anti-dumping and countervailing duty investigations. So it is not nearly as detailed, it is not nearly as spelled out in the law, all the various procedures. But that being said, BIS had a full day hearing at the Commerce Department. Several other cabinet agencies represented at the hearing, a day's worth of witnesses. Many of them were asked questions, a full investigation and 200-page report at the end on both industries to support the finding of whether or not the increased imports were a threat to, or are a threat to, national security defined in this broad way under the statute. So, and again, many of the underlying problems that we've talked about already with respect to China in terms of overcapacity and sort of dominance in steel and aluminum were thoroughly investigated. And the president's decision, of course, also went through a detailed interagency process as has been done in the past. Maybe I'll stop there just in terms of the background and leave it to others.
Jeannie, can you tell us a little bit about what's happening before the courts?
Sure. The constitutionality of the statute is not an issue in the current challenge, and this is one of the rare trade statutes that actually has gone all the way to the Supreme Court. And in a case called Algonquin, the Supreme Court held that Section 232 was not an excessive delegation of authority by Congress. So that issue has been resolved. The claim in the current case, which is brought by a very large Russian steel company, is that the decision was a pretext. And their claim is overtly modeled after some of the travel ban cases that have cited tweets and said that the travel ban was for different purposes than officially announced. And the claim is that that is also true of the Section 232 steel determination. The Court of International Trade denied the plaintiff's request for a preliminary injunction. The court did find that they were irreparably harmed by the 232, that because the duties would make it impossible for them to sell into the U.S. market, but found that the plaintiffs were unlikely to succeed on the merits of their claim because the president's action was non-justiciable. That decision can be immediately appealed to the Court of Appeals for the Federal Circuit, but the case will also proceed on the merits before the Court of International Trade.
Clearly, there was an option to use the conventional safeguard here with respect to steel and aluminum, and that wasn't chosen. Could you say a little bit about what are the differences in terms of, had a traditional safeguard been used, what sort of constraints would have existed that don't exist under Section 232? Including with that would be in terms of the timing for the remedy itself, and so forth.
I think it's Beth's turn to talk.
I'm doing inequality.
I mean, they're very different statutes. They focus on different objectives. They assign primary responsibility to different agencies, although both involve a large interagency component as well. And they both vest tremendous discretion in the president to make a final decision.
There's no time limit on this remedy, is that correct? In terms of this,
I don't think so.
there's no time limit.
No, not on the
Right.
232.
So typically, with a safeguard, it'd be a 3 years, 1 day, or now it's been expanded to 4 years, but here there's no time limit.
Yeah, and of course, the major difference would have been that the investigation would have been at the ITC, which would have had to make the findings of
Right. Which is an independent agency, I guess, is also a difference in the taking place within a agency which is directly connected with the White House. So it's a more political agency as opposed to an independent one.
Go ahead.
It's
I'll let you.
Pushing people.
well, the Department of Commerce is part of the executive branch,
Yes.
and the ITC is an independent agency.
Yes.
I mean,
And prides itself on that.
I think there's two ways to look at this. On the one hand, I think it gives all of us in this field a great deal of comfort to know the ITC has looked at a situation because it has a tremendous amount of expertise and it's very thorough and it is very independent. On the other hand, there are companies and lawyers who are pleased that they have a greater opportunity perhaps to make their case to executive branch agencies in proceedings that are more informal.
Yes. Could I say a little bit more in terms of, in terms of contacts and lobbying and so forth in a 232 proceeding, is it different opportunities for affected industries than there would be when having to go before the ITC?
Well, certainly in that there's no lobbying of the International Trade Commission. So, but although I will say in sort of related to that, in the safeguards case, USTR took some steps this time around to make the process more transparent as well, and actually held hearings in the presidential phase of the safeguards investigation. So the first time it had ever done that, I think arguably to address some of the WTO concerns from that were raised by past safeguards cases. So and to make the process more standardized and less susceptible to any of that activity. I think the other thing to recognize, and again, I'll take off my petitioner's hat, I'm sure it was surprising to many people that the president and the administration chose this vehicle of 232. But as Jean said, it has a lot of discretion, just like a safeguards remedy at the end of the day has a lot of discretion to it. And I think there is a lot of agreement on the underlying problems of steel and aluminum overcapacity and how to address that, and also the issue that negotiations alone aren't going to solve that. There have been negotiations for decades at the OECD on steel overcapacity and subsidies, and it really hasn't made any progress. So I think, 232 was definitely one of these examples of a tool that hasn't been used for many years, being dusted off by this administration and put into play. But I think there's more agreement on the fact that there's a fundamental problem here, and this was the route that the administration chose to take.
Yeah. I mean, if I recall, one of the first acts of the administration was to ask USTR to provide a report on what instruments are available that could be used to raise tariffs. And this was one of the instruments that was available, and now it has been used for the first time since the creation of the World Trade Organization. We'll turn to another instrument, and that is Section 301, which is in the news over the last few days. Section 301 authorizes the United States, asked the USTR to make an investigation with respect to any conduct of foreign countries, which includes conduct which is unreasonable and burdens U.S. commerce. And so if we could talk a little bit about that. As you know, the USTR issued a report with respect to China's intellectual property practices, listing 4 of them, or 4 categories, and then said that it created a public notice with respect to a list of goods which would result in retaliation against Chinese imports in the amount of around $50 billion. And China then, according to many commentators anyway, said that it was going to retaliate, but it didn't list the retaliation against, for example, soybeans, which would be a major concern in the Midwest, but it was targeted to have some political impacts in the U.S. decision-making process and to put pressure on Congress. And in return, of course, as we know, last night, President Trump said that he has asked the USTR to look into whether or not, in fact, it may be an extra $100 billion, which would be $150 billion worth of Chinese imports. In which case, what does it? It's not, of course, an official USTR finding, but if you could, Irving, since you worked a little bit or you worked for a great deal of time in terms of Section 301, if you could let us know how it's used traditionally. What the procedures are for USTR in terms of notice and comment, and where this particular statement of last night fits into everything.
Okay, good. Now, of course, the ITC hasn't been involved in this process at all, but from 93 to 98, I was chairman of the Section 301 committee at USTR, and it's a statute that's near and dear to my heart. I will say, and sometimes I've actually thought it was a brilliant statute, and it was put in the 75 Trade Act so that because Congress wanted private companies to have a vehicle to get the government to address their complaints about foreign unfair trade practices. And so it has a petition process where a company can file a petition, and there are very strict time limits in the statute as how quickly USTR has to respond to that petition. They have 30 days initially. And then they have to take action within a year once they initiate the investigation. But it has also, in addition to sort of requiring the government to take action, it also has a number of procedural safeguards. So when you do when a petition is filed, USTR has to go out for public comment. If there are other domestic industries that say, wait a minute, if you take on this complaint, it's going to adversely affect other U.S. export interests, they do have an opportunity to come in and complain about that. And those USTR, those comments are public and all. Mm-hmm. And then at the end, and the statute can be used, and the USTR argued this is at the end of the Uruguay round, that the statute could be used to enforce our WTO obligation, our WTO rights, but it also could be used when there were, say, practices that did not violate the WTO. And during the 80s, there were a number of cases on intellectual property where USTR used it, and went after developing countries, and they would often, the threatened sanction was withdrawal of GSP. You know, it's unilateral, something we give, we can take away. And one of the reasons why you have the dispute settlement understanding in the WTO is because a lot of countries got tired of the U.S. using 301 to pressure them to make changes in their trade laws. But in any case, in terms of if USTR accepts the petition, they initiates an investigation, and if it's a violation of a trade agreement, you go to the trade agreement dispute settlement procedures. If you're not alleging a violation of a trade agreement, then you really have a year to investigate, which really means negotiate with the foreign country to try to get them to change their practices. And if at the end of that year you haven't resolved the complaint, then USTR has to make a determination and say, what are you going to do about it? And traditionally what it means is, okay, we determine that there's been the practice is a violation of a trade agreement and they haven't rectified it, and so we were going to retaliate, or they haven't, didn't violate a trade agreement, but it's an unreasonable or discriminatory, and it has to burden, in that case, it has to burden U.S. commerce, and then the trade rep can make a proposed retaliation. Have to publicize, make a federal register notice the USDR, and the president is really delegated to the USDR the authority to do all of this. And so the USDR has to, say, this is what we're going to do. We found a violation, or have determined that these practices are unreasonable, and propose to retaliate. And traditionally, it's been 100% duties on the products on which you're going to retaliate. You publish retaliation lists, have another public hearing at which people can come in and complain about, please take this product off, it's unfair, or you're going to shut down an industry. I worked for the Port Authority in New York and New Jersey, and they were using 301, the retaliation when the EU enlarged and we didn't get satisfaction, and often we were coming, and 25% of U.S. wine imports used to come to the Port Authority in New York, New Jersey. I used to come into USDR and say, please don't hit us, because don't hit us disproportionately. So this process of having a public hearing and an opportunity for people to come in and sort of say why the proposed retaliation or why hitting a particular product would not be in our self-interest is important, because you don't want to shoot yourself in the foot. And I've often said retaliation lists are the most bloody thing you can do in government, because you're just never sure who you're going to hit. But anyway, that's the process, and that's the process that's been followed here. There's a federal register notice out there with proposed retaliation, and the USTR has stated the grounds on why he wants to do it.
Just to amplify what Commissioner Williamson just said, since the Uruguay round, Section 301 has really been on the shelf, and the only way it's been used, I believe, has been for private entities to try and encourage the U.S. government to bring a WTO case. So there have been 301 petitions filed by companies or industries, or in some cases even members of Congress, I think, on things like currency manipulation, green energy policy, things along those lines. So here again, the administration is taking another tool in the toolbox, dusted it off, and I do think it's a very clever strategic use in terms of filing this case involving China's acts, policies, and practice related to technology transfer, the requirement for joint ventures, IP protection, cyber hacking, all of these, because it's not exactly clear that China is subject to WTO obligations in this area. And so, therefore, the United States can argue and has argued that it could use its discretionary authority under 301 because it wasn't clear whether or not these practices that surely burden and restrict U.S. commerce are directly governed by obligations under the various WTO agreements.
I would maybe just make one sort of bigger picture point. In the last 3 statutes that we've talked about all involve a great deal of presidential discretion. And I was on Capitol Hill in 2015 when we were voting on trade promotion authority. And when you think back to that debate and how worried some members of Congress were that Congress was ceding too much of its discretion to the president, and the argument was, no, Congress retains plenary authority over trade. It's interesting to see now that the president has used these tools, that's the people who voted for TPA who seem to be the most upset about the way he's using these tools, and the ones who didn't, who say, well, this is what the result is when the president is given a great deal of discretion.
If I could just add a couple points. One is that under the schedule announced by USTR, no action likely will be taken until the very end of May or the beginning of June. So we probably have 2 months during which time anything could happen, and hopefully tariffs will be avoided. I would also emphasize a point that Irv made, that USTR takes its hearings and its comments very seriously in the Section 301 area. And I was actually the chair of the 301 committee for a year before Irv took over and made it much better. But it's so if you have clients who might be affected by this, it is well worth making your pitch to USTR that people will lose their jobs, or people will not be able to get medical treatment, or there's a slightly different product that isn't on the list that would be better to put on the list because it would hurt fewer people in the US, but yet still accomplish the government's goals. So the lists do get adjusted considerably as a result of the hearings and the comments. Another point I would make is that, well, our allies, are alarmed with this sudden use of these old statutory tools, and all of us, watch the market and watch our pension plans and hope that things remain stable. I think among our allies there's some crocodile tears, because I think they're also not completely unhappy that the U.S. is going after China on steel capacity and its IT practices in China, which don't only affect U.S. industries. And a final point, which may be getting into the next area, is that both China and the U.S. have gone to the WTO with respect to this particular Section 301 action. So I think it's premature to declare the WTO dead. Even the U.S. is using it for this particular investigation. Maybe not successfully, as Tim pointed out. It's not clear the WTO applies, but at least we did go to the WTO, which is what we said we would do when the WTO was created, that if we use Section 301, we would use it consistently with WTO procedures.
So let's turn to the international level. It does strike many as a form of defiance of the WTO to, even if use of Section 301, not to enforce WTO obligations, but rather to enforce other obligations. And the form of enforcement is to raise tariffs, which, at least to, I would say, most people, looks like a clear violation of WTO rules. And so that would be the Section 301, and we're talking about massive tariffs, not just a small amount of tariffs. And second is with respect to the national security defense as to whether and how this puts the WTO in a very dispute settlement mechanism, the appellate body, in a no-win situation. That on the one hand, if it doesn't provide, if it just is a get-out-of-jail-free card, anybody can use national security. And this is going to affect a lot of U.S. constituencies. I mean, national security, you can imagine China raising this, that we need to not depend on Silicon Valley and U.S. technology. We need to develop our own technology. So that's a national security defense. Or other countries have been talking about food security for a long time, India and others, and that we need to block U.S. agricultural imports into our country on food security grounds. It has something now been opened up, which really means that international dispute settlement and a rules-based system, or to cite John Jackson, where law as opposed to power was to prevail, has now, that was a quaint bracket in history.
That's a gigantic question, so I'll start with a small piece of that. You're right on, I think, on Section 232, that the WTO issue there is Article 21 in national security, and it has been sort of a third rail that countries don't want to challenge or touch. But it's going to be tricky because, first of all, the language of Article 21 is a little convoluted, but it indicates pretty clearly, I think, that it is the country invoking the national security exemption that is allowed to define what constitutes national security. It says, nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests. And then it goes on and puts it in a couple of categories. But so, that would seem to indicate that that the president can do this. On the other hand, I am clearly very uncomfortable with China defining that censoring the internet or any of 100 or 1,000 other things it does are for its essential security interests. So that is a huge challenge to the system, and it's not one that's going to be easily resolved.
Yeah.
I think, aren't there a number of ways where we are such a transparent, we have our warts, but we are such a transparent government compared to a lot of other governments. China is already able in any number of ways to execute domestic policies that, if they were done more transparently, would be in violation of their WTO obligations. So it's almost like there's an imbalance there, and I'm not sure that it's all going to rise or fall on this exceptional use by the United States of Article 21 with a president who is unusual. I'm not convinced that it's all going to fall apart. It might, but I'm not convinced.
Yeah, I mean, it's just, you know, one of the great inventions with the WTO is to reverse the consensus rule. That it used to be you could block the adoption of a panel report if you refuse to recognize it and provide consensus. But now one can imagine just raise an Article 21 defense to any variety of claims. But it's maybe we should turn to critiques of the current system. At the same time, it's been remarkably effective. It may be very inopportune. I was writing a book called Investing in Law about how countries around the world had invested in building legal capacity to address WTO matters, and this would be China. It created an Office of Cleanup of Laws. It changed 3,000 laws. It was arguably within 2 years after it joined the WTO. Brazil created a specialized office. The Attorney General's office in Brazil actually is to review any Brazilian legislation regulation with respect to WTO compliance. You see India trade bar has arisen and so forth. In Africa, you see free trade agreements being signed. I was just wondering, in terms of, is the United States in a sense an outlier that you're going to see, or is the United States so important that actually a rules-based system will fall apart without it? What sort of developments do we see in other countries? Yeah, Irving?
I'm not going to answer that last
Yes.
question, but I do think it is important, and I think it's particularly important at a meeting of the American Society of International Law to look at all those positive things that are going on, sort of to build the rule of law in the area of international trade. And you talked about that African continental-wide free trade agreement, which I think it's about 45 countries, and they've been talking about it for a long time, but they've actually signed it. You've got progress in other African regional economic commissions and organizations in Africa progressing. You have the trade facilitation agreement that a lot of developing countries have signed. I guess there have been, 500 WTO disputes, 350 of which have gone to a decision. So it's useful not to forget that these things are going on, because otherwise, I'll just say that it's just useful to remember that.
Okay. Yeah. Tim. Oh, sorry.
So I'm not. I mean, look, there's a lot of views on where the WTO is at. When I teach my class at Georgetown Law, I point out that the dispute settlement process has been enormously successful since it was created. That compliance is very good, not only by the United States, but by other countries, and that leading commentators have said it's not only the best international trade tribunal, but the best international tribunal, which also includes a lot of other bodies like the World Court, so that's quite a statement. At the same time, there are flaws in the dispute settlement process, and we could spend hours listing them. It's a very plaintiff-friendly environment. You can file a complaint alleging as many violations as possible. We've seen an upswing in this where U.S. practices have been challenged with, by 20 or 30 counts filed by India or Korea, or even our neighbors to the north, Canada, challenging our use of the trade remedy laws. So there are those kind of things. Cases are becoming more and more complex. The compliance process is dragged on, and clearly, this administration has a more immediate concern, which is it feels like the United States is losing in dispute resolution things that it had protected during the Uruguay round negotiations. And so the WTO is a two-part entity. It negotiates agreements and it has the dispute settlement function. Well, and other things like trade facilitation too. But if the negotiation process isn't working, then there's harm in the dispute settlement process as well. And I think that's what this administration is focused on, to the point where it's now blocking appellate body members and escalating this dispute to a point where something's going to have to change. I think something will change, and I think the WTO will find its way through, but this administration is extremely concerned about what has been going on, and the fact that there are not negotiations to match what's been going on the dispute settlement side.
So let's turn to the sort of this big question of how did we get here, and how do we move forward? So that we're talking, now about risks of major trade wars. Some could view this as, in a sense, in game theory, the game of chicken of who's going to drive everything over the cliff. And clearly, one of the major challenges in the United States is the rise of China. China is an economic power, really accelerated, of course, after the 2007-2008 financial crisis. China, of course, its explicit policy is to overcome what it views as the middle income trap. It doesn't want to be just a middle income economy. It wants to become an advanced economy. So it's using all sorts of measures, including requiring companies to provide access to software and so forth, which has led to the 301 proceeding. What are the different alternatives for dealing with the rise of China? We hear the argument over again that could it be done through the current WTO rules system, or is something different needed, and if so, what?
Well, again, I don't know what the ultimate solution is. I think that the WTO can be used, but it may not be the only thing. I think you pointed out the systemic problems. One resource I would recommend, there was an article in the Wall Street Journal last November, before some of the recent events of the last few months, called How China Swallowed the WTO, and how there were a lot of expectations about what would happen to China when it was admitted to the WTO, and that some of the issues of overcapacity, state-owned enterprises, currency manipulation, tech transfer requirements, subsidies, internet restrictions, and so forth would be addressed, and it just hasn't happened. So the United States now has appointed an ambassador to the WTO. I think it will be interesting to see if this administration is going to continue to file offensive cases, challenging trade barriers abroad in China and other countries, or not, if it wants to sort of force the issue that I talked about earlier. But there are huge systemic problems there. I think Jean is right that our trading partners share these concerns. In fact, I believe the EU and Japan joined the case that the United States has filed, at least in the consultation phase. So I do think some of this will play out at the WTO, and some of it will play out in negotiations to try and resolve this non-trade war that we seem to be in the last 60 to 90 days.
I would actually.
No, go ahead.
I think we've been in a trade war for a long time. I think the idea that we're starting a trade war now is fallacious. And if you're familiar with the systemic process in China, and you don't have to be anti-China, it is their development model. But it is a development model that comes, and you can trace it if you look through David Otter's work. It comes at the direct expense of manufacturing jobs in the Midwest, in states that voted for Donald Trump with margins of 10,000 to 60,000 votes. So I don't think these are disconnected. From my view, these are not disconnected things. So the question is legitimate: how do you respond to the trade war? But I think we've gone down the wrong path when we focus on whether we're at the beginning of a trade war.
Okay. I also want to chime in. This is, again, very personal views, but I always said a good trade policy starts with a good domestic economic policy. And I think, and if you look at the growth of inequality in the U.S. and the impact of that, look at the results of the election and things, the need to figure out how to deal with that problem, I think, is fundamental. If we're going to stay competitive with China going forward, we're going to have to deal with some of our domestic economic problems. We have to deal with our infrastructure, of course, building infrastructure, education, you know the list, all of those things. And I do think that's not to be forgotten, and because if we don't really work on those, it's going to be
I mean, we haven't had a
Very hard.
competitiveness program since 1988.
Yeah. And I was so optimistic when I saw the Trade and Competitiveness Act of 1988, but what's happened? And Pete Peterson, who just died, I guess, last week, he was a young staffer in the Reagan administration, in the Nixon administration, and wrote a paper on the need to deal with trade adjustment assistance, the need to do with a number of the problems that we're talking about now. Edward Alden's done a book called Failure to Adjust, which starts with that and goes forward on the failure to have an effective trade adjustment assistance program. But these are all examples of things that we should have done and we need to do if we're gonna really, I say,
If I could just add
people
one more
trying
thing.
to.
Pete Peterson went even further than that. I was reading a book on the 70s, the pivotal decade. He advocated an industrial policy. So, I mean, he is an avid free trader, but he came to the conclusion in the 70s that the United States had to have a tripartite commission to develop an industrial policy. And I feel like if you even invoke the phrase industrial policy today, you get run out of town. So I think something has to change in that discussion.
So what would a progressive trade policy then look like that would directly address issues of inequality, the precarity of jobs, the loss of wages, and so forth that have triggered, whether or not trade is to blame? Certainly we know politically it's easy to blame trade because it's foreigners, often foreigners of a different color, different race, who are causing the problems. And so if we're going to try to have a more progressive trade policy, which is not just simply pointing the fingers at foreigners, but actually seeing what we can do ourselves, what would it entail?
I mean, I think what you were saying about our domestic economic policy, I mean, our most important consumers, I think, today remain within our own borders. So we tend to put this all on the international trading system without remembering that we're actually training to supply our own citizens and residents. So I do think we need some kind of policy training and an investment in our workforce and some kind of plan for where we expect to be competitive. Germany has a plan, China has a plan, we have no plan. I would also, I think the way we've talked about some of the issues that show up in trade that are considered designed to address inequality get framed as social issues, and I think we have to stop doing that. Labor chapters in trade agreements are not social undertakings to make people feel better. They are a fundamental element of how the U.S. competes with other countries. So I think we need to reframe the way we talk about it so that these types of undertakings are more appealing to a broader base of people. I also think we're going to go in the direction of focusing on supply chains, and whether that is driven by government policy and whether we undertake actions. We closed a loophole that allowed imports made with forced labor. We closed that loophole in 2015, which now means that importers have an incredible responsibility to know their entire supply chain, because you can't import anything that was made in whole or in part with forced labor. So I think we're going to get much more focus on the entire supply chain, knowing your supply chain. And I think that will partly come from the government, but I also think it's coming from the marketplace. And I think consumers are much more interested in how things are being sourced and the conditions under which they're being sourced. And I think we're hearing increasingly that millennials as employees are demanding that the companies they work for undertake more ethical business practices.
Okay, yeah. So I think what we're saying is, you got to continue to go after foreign unfair trade barriers using all the tools that are available. You don't stop negotiating trade agreements, but you really got to do something at home so that you can take advantage of when you get those trade agreements, you want to be able to take advantage of them. And the reforms that I think we're talking about are things that need to be done, as well as a more equitable distribution of income, because otherwise you're not going to be able to get a trade agreement through Congress.
Yeah. Did the TPP represent an advance? Did it not go far enough? Do we need to think about new instruments, such as instruments to combat social dumping or other types of unfair trade that are not covered in our existing laws?
Why don't you take it?
I mean, I have mixed feelings about TPP. Certainly, the labor chapter was similar to labor provisions we've seen in agreements we've had since 2010. I think there were efforts made to try to address the unique situation in Vietnam. I haven't checked since the text has become public, but I think that's been suspended since the United States dropped out. And if that's the case, and they're calling that a progressive, that's the progressive TPP, that is a big step back. And I think you don't want the United States to be the sole country that is pushing for progress on binding enforceable labor obligations in our trade agreements. So I think that's an issue. What was the second part that you asked?
Oh, social dumping
Social
or new
dumping.
types of instruments that don't exist.
I mean,
that
I
we
think
can
it's
put
a
in trade
real,
agreements.
I think when you look back, so I don't know, I don't think this is well known, but social dumping was floated when we were negotiating the GATT. We ended up just doing price discrimination as part of the dumping code. So we have a really long history of being worried about social dumping, and I think that it's an oversight for the WTO not to be tackling labor and environmental issues. So I think that there is in fact room for that.
Yes. Anybody else? Yeah, Jean.
Now, this goes back to a question you asked a few minutes ago about, will other countries be rules-based or something in going forward without the United States? And I think that's what bothers me the most is I don't think they'll have any problem going forward without us. They're going forward with TPP. They're going forward with lots of other trade agreements without the United States. There were parts of TPP I didn't personally like either, but I do worry that if the United States is retreating and taking a different path where we're just going to take bilateral or even unilateral actions for trade and the rest of the world is going on without us, then either another leader is going to emerge and hopefully, won't be one that is disfavorable to the United States. But also what happens when the United States wants to get back on board 10 years from now or 4 years from now? What will that look like? Will we then be signing on to agreements that we like less than TPP? So that's my main concern. But I think we've trained all of these countries and they are very capable of continuing without us.
Just one other thought, which is, this administration has talked about pushing ahead, on a bilateral basis. But I think the concerns that you and Elizabeth raise are good ones in that there's always going to be business to push forward provisions on state-owned enterprises or TRIPS Plus or digital economy. Who's going to push for those other provisions to put those in a revised NAFTA or UK free trade agreement or a free trade agreement with Africa? So I think that is an important question that we have to address from a policy perspective. There is plenty of interest in this administration to do free trade agreements, but what they will contain, and will they just be business vehicles or will they be something else?
Yeah. But just a side note, I had understood that in the context of TPP, Mexico was changing constitutional provisions with respect to labor rights, and that once the U.S. dropped out, that process stopped.
And they're actually unwinding them.
And they're unwinding them, yes. No questions. Please? Yeah, no, so this is the time. Please come forward there's microphones on the side. We'd love to hear questions from many of you. So please step up, and it's your opportunity. Great, thank you.
Hi, my name is Matthew Hurwitz. I'm from Brooklyn Law School. Thank you all for speaking today in this wonderfully big room on this subject. I actually had two questions, one of which I'm not sure how much personal view you'd have to put into it, so feel free to skip over. My question is, some of you have talked about the political or media aspects of your jobs, and over the course of your career, where's the sort of intersection between jobs in trade and public consciousness of political issues? When something like NAFTA is on everyone's mind, or nowadays there's a certain attitude, are attitudes nowadays exceptional, and do they play an exceptional role in your lives or your jobs, or is it, a cyclical sort of thing? My second's kind of a general question. In terms of the TRIPS agreement, at the time when that came into play, and it was decided that that would go through the WTO route instead of being through WIPO or some other area. Did that make sense to you as an evolution in this area of law? And in hindsight, do you have any problems with it, or is it just a matter of fact nowadays?
Okay. Let's take one other question, Jennifer, and then we'll take a second round. Yes, thanks.
So I wanted to go back a little bit, if I could, to the national security debate. I love, Jean, your comment on sort of, do we have a new definition of a domestic industry? So my question, I guess, for the panel is, do we have a new definition of national security? Because to me, when you look at this 232, and particularly if you look historically, I mean, the 232s in the past had really been about, is the United States overly reliant on imports for critical materials, and particularly imports from, let's say, less than trustworthy trade partners. And to me, if that's really your sort of notion of what is national security, the answer in steel would be a clear no. We are not overly reliant on imports, full stop, and to the extent that we are, we're reliant on Canada and the European Union and our friends. So it's clear in the 232 context we've morphed into sort of economic security, that in some way, and yes, the 232 statute has a broader definition. But internationally, the WTO definition would remain, is something essential to our security interests, yes, self-judging, but specifically relating to fissionable materials, trafficking in arms, or a time of war. So I'm just curious whether we have a new definition of national security that encompasses this broad notion of anything that we deem to be in our economic security and the rest of the world does not. And if so, how do you see that playing out as we go forward? I would say particularly in the context when the United States and Russia have taken the position at the WTO that as soon as a member of the WTO invokes the word Article 21, the panel has to put down its pens and go home, and is in no position to adjudicate the dispute at all. So how do we resolve this difference? Thanks.
May I follow on with
Sure, please.
Yeah, my question was going to actually be very, very similar to that. It would seem to me that in the current international situation, that we're in a competition between whether or not the ultimate successful way that the world is going to be run is through a totalitarian political regime and a state capital regime versus the democracy and an open values and a capitalistic society, more privately run. I mean, I think that's the international competition we're in. And it would seem to me that economics conflicts and military conflicts are just two forms of the same thing. And so we're in a battle for the future. And the question I have for you to follow on with that is, are the changes that the President's made on his trade policies intended to level the playing field more so that we can continue to build up our strength for this conflict and not just simply empower people like the Chinese to have more assets so that they can build Belt and other type of initiatives and invade into the South China Sea? It's all one of the same. And in the opinion of the panel, are the President's trade policies attempting to level that field so that we can engage successfully in that conflict?
Okay. Oh, yes, Irving.
Can I take
please.
the easy one?
Yes.
The first question?
Not the third one?
No, it's the first one. I didn't quite understand your question, but let me just, as you're talking about a trade practitioner and the political side, think about it. When I was at USTR in the 90s, I've lived in New York for the last 30 years, and Friday nights I would take the bus up to New York and get on the A train. And I would sit down and look around and sort of think, what I'm doing in Washington, how does this affect the people here? And it's kind of humbling to sort of to get outside of Washington and to realize the day-to-day life, the problems that people are dealing with every day, and not to get too self-absorbed in what you may be doing in Washington, because there is a difference. Although I must admit, the one thing I think NAFTA was a change just because of the political debate that went around it. I mean, WTO implementation passages that was actually went relatively smoothly compared to the debate that's surrounding NAFTA. And that debate about NAFTA is never finished, and that's one of the problems, particularly for someone like myself, being a liberal Democrat and working on trade policy. On the WIPO and TRIPS, Also in their late 70s, I was like the WIPO liaison, because I was in I was the junior officer in the mission in U.S. mission in Geneva, and they assigned me to WIPO. Of course, the patent office was the people doing the negotiations. But they were going on a multi-year process that they never finished on the revision of the Paris Convention. And also, none of those WIPO agreements had, dispute settlement provisions, enforcement provisions. So the wonderful thing about the TRIPS agreement was it took all of the standards that were in the WIPO agreements and just made them enforceable. And that was the big step forward. As I said, you remember we used to have to do the 301 retaliations before the WTO to try to get countries to strengthen their IPR responsibilities. So, thanks. That was the easy one.
So very briefly on TRIPS, and a lot of that happened before my time, but at least the way I try to explain it to my class at Georgetown is that was highly sought after by the US and the EU in return for things like binding dispute settlement. And the challenge with TRIPS is, the balance between protecting the innovation rights, patents and so forth, versus protecting dissemination of that knowledge to others, and that has continued to be a problem that plagues the WTO on public health and how to deal with AIDS and TB and malaria and compulsory licensing is still there. So it's a balance. It's been made a more heavy balance toward innovation rights as opposed to spreading those rights, but still certainly a leap forward. On national security, Jennifer, I don't know. That's a tough one. I would say the definition is arguably broader than just national security. I just looked up Article 21, and it says relating to traffic in arms, ammunition, implements of war, and to such traffic in other goods and materials as is carried on directly or indirectly for the purpose of supplying a military establishment. I can see why we've avoided trying to have the WTO interpret that phrase, but I think you could argue that it doesn't just mean implements of war, and that it does mean that we have to have an infrastructure that can carry on not just direct, war implements, but also the other things that support economic and infrastructure and so forth. I'd also note there's been a new 232 filed on uranium mined in the United States and whether imports of uranium are a threat to essential security. And the facts of that case are, I'm not involved at all, but are very compelling in terms of the United States mines almost no uranium these days, and it appears that most of our uranium comes from Russia and China. So where does that leave us, and is that something that the administration will want to move forward on? It hasn't yet initiated that 232 investigation, so I'm watching to see what happens. So I'm sorry that's not much of an answer to your question. We might have to take that on at happy hour unless someone else Shane, give it a shot.
Yeah, okay. I'll take a stab at questions 1 and 3, but this would be a good time to remind everyone that we're speaking in our personal capacities. On 1, the question about political media, I'm not sure I understood the question, but I would say that in my decades in the U.S. government, I have always found that I could give my honest legal advice and even judgment about what the government should do, and while my views are not always adopted, I have never been disadvantaged or punished or fired or transferred, or nothing bad has ever happened to me for giving my honest advice. And on Jennifer's question, I don't know if this is a new definition. We cited every time 232 has ever been used in our brief, and if you look at it, it has been used over a wide variety of circumstances. Admittedly, as you say, often because we didn't want to become overly dependent on Iranian oil or something. But the statute itself is extremely broad, and my personal view is that the president's action here did not reach anywhere near the outer boundaries of the statutory authority. The president was honest, and the Commerce Department was honest in saying that they were addressing overcapacity and overproduction by China, and I think that makes the country exclusions rational. It's consistent with what the government is trying to do. The courts may decide that that's not within the scope of Section 232, but I think that is their goal, and that's why you end up with this situation where the majority of producers are actually excluded. But it's because the goal is to try to get a handle on the overcapacity and overproduction, and the agreements that these countries are providing at least impose some sort of restraint. And on the WTO, this might be folklore, but I recall that Holland once claimed that wooden shoes were necessary to its national security. I don't know if it won the case.
Swedish cotton, yeah. Yeah.
Okay, but steel
That was my
sounds,
first
steel
meeting
sounds
in
a
the
lot
GATT.
closer. Okay, it was in the GATT, right, many years ago. But steel sounds a lot closer to national security than footwear.
I'd just say one thing, Jennifer, to your point about relying on imports. I think that that's been the way the statute has been executed for the last however many 232s that we've done. But I'm not sure that we should be 100% reliant on imports, even if they're coming from allies. A friend is writing a book on monopoly, and in the 1940s, we actually didn't have enough aluminum to make airplanes because Alcoa was constraining production. For certain industries, you might want to be in a position to actually be able to nationalize them, and you can't do that if all of the production is located overseas.
Okay. Thank you, everybody. Let's thank our panelists for this wonderful session.